When a dog bites someone, we wonder what caused it. We wonder why. A dog is man's best friend, so something must have made it happen. Could it have been the victim? That brings us to the law of provocation. Provocation is a complete defense in a dog bite case. That means it can defeat or minimize every cause of action, whether it's based on a dog bite statute or on negligence or on violating an animal control law. The provocation defense beats all of them. But what has to be clearly understood is that cause and provocation are two entirely separate things. An incident or an action might clearly be the cause of a dog attack and yet not trigger the defense of provocation. Here are some examples. Petting a dog might cause a dog to bite you, but that's not provocation in the legal sense. Walking near a dog, turning to face a dog, getting up from a seated position near a dog. These things might trigger a bite, but they don't constitute provocation. Talking to the dog owner, that's another example of something that is not provocation. Holding packages and walking toward the dog owner, again, that's not provocation. All these examples are from real appellate court cases. So, how do you decide whether a victim's actions trigger the defense of provocation? You judge the dog's reaction by the same standard as you would judge a person's action under the doctrine of self-defense. Ask whether the victim hurt the dog, or hurt the dog's owner, or the dog's puppies. If the answer is no, ask whether the victim's actions were an obvious threat to do any of those things. You also ask whether the victim was trying to take away one of the dog's puppies, or whether the victim had startled the dog awake. There's an important limitation on the doctrine of provocation, and that is, the dog's reaction has to be proportionate to the threat. In other words, if you step on the dog's tail and it bites you, that's one thing. But if it mauls you for 5 minutes, that's not considered provocation. Another limitation has to do with the dog owner's negligence. If you go to someone's house and they let you pet their dog, but they don't warn you that the dog has a painful ear infection, and you touch the ear and the dog bites you, the defense of provocation is not available because the dog owner was negligent by not warning you about the ear infection. These are just some examples of what constitutes the defense of provocation and what doesn't trigger it. It's a defense limited by common sense. Do not confuse cause and provocation. Check out the link at the end of this video to read more about this at dogbitelaw.com. I'm its author, attorney Kenneth Phillips.